When you're arrested for domestic violence, if you bail out of custody, there's generally going to be a gap between when you are released and your first court date. Now, some people decide they're just going to wait and see what happens. In this video, I'm going to explain why that is a bad idea. My name is Jamahl Kersey. I'm a criminal defense attorney in San Diego, California. And like I said, in this video, we're going to be talking about that wait and see approach and why that's a bad idea. And I'm going to also propose a solution that is much better and much more effective. Now, you're definitely going to want to watch until the end because I'm going to be giving some very important information here. So people who decide that they're just going to wait and see what happens, a lot of times they get that advice from either friends or a family member who has been through the system or has been arrested in the past, and they told them, hey, I didn't do anything at all. I just showed up to court and they didn't file charges against me. So I advise you to do the same thing. Now, the reality is there are situations in which a person is arrested for domestic violence. They then bail out, and then whether their court date is a week later or 6 weeks later or 2 months later, they show up on that date and the DA has declined to file charges and they never end up getting charged with a crime. And so let's kind of break down what ends up happening between the time you're arrested and released from custody and that initial court date. So the police will have already investigated the alleged criminal activity. Someone called 911, whether that's the alleged victim or a neighbor heard a noise and decided to call 911, and police respond to the situation. So they end up attempting to take your statement. So you're the one who was alleged to have committed the violent crime. So they'll try and take your statement, and you may or may not give one. My advice is not to give one, but they'll also have tried to take a statement from the alleged victim. At that point, they will have those statements. If there are any witnesses, then they'll have the witness statements as well. A lot of times they'll seek to take photographs. If there are any injuries, they'll take photographs. If there's, if it's in the house and it's all in disarray, things got thrown around, things got broken, then they'll shoot video, but they also have their body worn camera footage. So all this information gets packed up and sent over to the DA's office. And there's an issuing DA whose responsibility is to review the evidence and ultimately determine, number one, if charges are going to be filed at all, and number two, if so, which charges will be filed. And so the wait and see approach would be basically doing nothing and just waiting and seeing what happens, hoping for the best, right? With the wait and see approach, you're doing nothing at all ultimately to influence the outcome. So I'd mentioned that I was going to propose a much more meaningful and effective approach, and that's what I'm going to explain now. So at Kersey Law, basically, we have a whole team of attorneys, of staff members, of investigators who are all going to contribute to building your defense and presenting part of that defense to the DA before they even make a decision. So we do that by having our defense investigators actually go out and interview the witnesses. If we have a statement from a witness who saw the event and can say that my client never did anything wrong, he never struck the victim, he never did anything that's being alleged, then this is going to be really powerful. But realistically, the most powerful statement is going to come from the alleged victim herself. So if we have her on board, then that can be really effective in terms of building our defense. You see, a lot of times these things happen, and the police obviously got onto the scene. They were called, but once they called, the situation blew up into something that no one could have ever anticipated was going to be the case. They didn't think that their boyfriend or their husband was actually going to get arrested. They didn't think that he was going to end up facing a misdemeanor or felony charge. They just thought, hey, I was going to call the police, and then, once this thing was going to settle down, we'd be able to go about our lives. Unfortunately, it doesn't go that way. And so naturally, the thought is, okay, from the alleged victim, hey, I can call the investigating officer and tell them to just call this thing off. I don't want this case to move forward anymore. And, that's a natural thought. And you would think that would be an effective approach. After all, it's the police who took the statement and decided that they were going to move forward. Well, can't I just call the police and then have them undo this whole situation? Unfortunately, there are a number of reasons why this is not the case, but I'm going to talk about two. All right. So number one is just from a practical standpoint of the police officer had already taken the alleged victim statement. He already took the notes from that statement and prepared his police report. And like I said, turned all that over to the DA. When an alleged victim calls that investigating officer up and says, "Hey, I want to make a new statement," or what I said originally was a lie, or I don't want this to move forward anymore, that person is creating extra work for the officer. Again, the officer had already turned over their file. And so unless the case is to go to trial, then there's no other involvement really that this officer has to have in the case. And so the alleged victim, by reaching out to them, is now creating extra work that they don't want to have to deal with. And so I've absolutely seen over the years where an alleged victim that was a girlfriend or a wife ended up calling the investigating officer or the detective after the fact saying, "Hey, I don't want this to move forward anymore." And then that officer or detective just responds, "Hey, it's out of my hands now. There's nothing I can do about it. I'm sorry, I can't help you." And as you can imagine, this would be a very frustrating and maddening experience for an alleged victim who doesn't want this case to go forward anymore. The other issue in terms of why reaching out to the officer or detective is not a good idea is because if that law enforcement officer is convinced that there was actually abuse going on, or there has been ongoing abuse, then a lot of times they feel that by pushing this case forward, that justice will actually be served, that the abuser in this situation will end up being charged with a crime and he'll end up being punished. He'll have to do domestic violence classes, and that's what they would like to ultimately have happen. So an officer or detective is not going to help to undo what they've already put in place in what they perceive to be the route towards justice. So that's another reason why they won't just close out the case. The reality is, though, a lot of our clients have no criminal history whatsoever. A lot of times they have a really good job, or they may have special licenses that are absolutely put at risk by the prospect of being charged with either a misdemeanor or a felony domestic violence charge. A lot of our clients are good family men. They're good husbands or good boyfriends. They're good sons. They're good brothers, good friends. They do a lot of wonderful things in the community. They may do volunteer work. They may be churchgoers. They're one of the best players on their softball team. There's a lot of different things about them that are positive that absolutely are not reflected in a police report. And so the DA doesn't know anything about a person being charged. All they really have are one-sided facts put in by the police in order to ultimately secure a conviction. So at this initial stage, what we're doing is we're presenting some of our defense, and also we're telling our client's story. This is a real person with a lot at stake. They have a lot to lose. And so then the question becomes, what is it that's at stake for you? What is it that you have to lose? If you were to lose your job, how would that affect your life? If you were to lose your job, how would that affect your children's lives? And if you know that you could possibly lose your job or possibly lose your license if you're charged with a crime, then wouldn't you want to do everything that you could in order to put yourself in the best possible position to avoid that from happening? If the answer to that question is no, then just waiting and seeing what happens is a solid approach. It's going to cost you nothing. It's not going to cost you any effort. It's not going to cost you any money. And, you're doing a coin flip, and ultimately the odds could turn out in your favor or they won't. But if you do have a lot at stake, if this does mean the world to you, then you naturally would want to do everything that you can to avoid charges being filed against you. So that calls upon having a solid, experienced defense team in your corner, gathering evidence, preparing positive information to provide to the DA with the end goal of convincing them not to file charges in the first place. And I can definitely tell you that this year alone, we've been able to do just that and help our clients avoid charges being filed in the first place. Now, I'm not able at all because number one, I'm an ethical lawyer, and number two, I'm honest. I'm not going to sit up here and I'll never guarantee to a client that we can guarantee that charges are not going to be filed. But what I can say is that what we're putting together, the investigation that we're doing, the witness statements we're collecting, the positive information we're preparing on your behalf, and getting that over to the DA, doing that is going to be basically everything that actually is within your control, within our control, in order to put you in that best possible position for a favorable outcome, which would be the DA declining to file charges against you.